Good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna PC. Today is May 27th, 2021. This is our community conference call that we hold every other Thursday to answer questions that have been posted. If time permits, we will answer new questions. There are two questions I marked as frequently asked questions. Let me jump right to it. The first one is about not reporting change of address to the USCIS and its impact on naturalization. So when you move until you are naturalized, even as a green card holder, within 10 days of moving, you are supposed to inform the government. You have to file Form AR11. If you don't do that, it's actually considered to be a misdemeanor, which means it's a crime. And also, you can be placed in deportation. The question before us is not about those two things, but the question is about the impact on naturalization. So my answer to this situation would be, I am not aware of anybody whose naturalization has been denied based upon an AR11 failure. I also looked at, this morning I had a few minutes, I looked at, just out of curiosity, any federal cases where there had been a litigation about refusal to grant naturalization because of failure to file AR11. I didn't see a single case. My guess is you should not have a problem in naturalization. This is a guess. But do make sure, if there is any question that asks you directly or indirectly about your AR11 failure in the Form N400, the naturalization application, make sure you cover that. Make sure you answer that truthfully. So, while the failure to file AR11 may not be problematic, the attempt to conceal that failure could be fatal. Make sure you don't do that. Okay? *5 if you have a follow-up question. *5. Press *5 on your phone if you have a follow-up question on this. Okay. Let me go on to the next frequently asked question, and then we can start on the regular questions. So here's a question about chances of getting an F1 visa when B1 visa was rejected earlier based upon a 214B denial. What is a 214B denial? A 214B denial refers to a section of the Immigration and Nationality Act, Section 214B, that basically says you have been found to have immigrant intent. It looks like you're going to become a permanent resident or try to become a permanent resident in the and of the United States. Therefore, we're not going to give you a temporary visa. And that typically applies to B1, F1, J1, these types of visas. There's no 214B on visas like H1, H4, L1, L2, which are called dual intent visas. With that said, now the question is, earlier I was to attend a company's global conference as a speaker, and my visa was rejected on 214B. A lot of young people from our company were so rejected. Now I'm going to go for an F1 visa. I've got the funding. I've completed with decent grades. So it looks like he or she, is it a he or a she? John Doe. It looks like a he. They have a legitimate claim to being a genuine student. So they should be able to get an F1 visa, but for that 214B. Is that going to be a problem? Is that usually a problem? The answer is, it is usually a problem, because 214B, which is, hey, you're going to become a permanent resident of the United States, and we are worried about that, we're not going to give you a tourist visa. F1 visa falls in the same category. That problem carries over to the next case. But would it be a problem every time? Well, a lot depends upon how the officer who interviews you looks at your case. Maybe the situation has changed, the circumstances have changed. What you have going for you is the fact that you are a genuine student, purely 24 karat gold, no question about it. So I don't see that being as an issue now. In the past, there was a 214B denial that is a little uncomfortable. It can carry over to your F1. Bottom line, it is difficult for me to assess what the chances are. How can you be better prepared? Make sure you tell the truth. And your strongest point is the fact that you are a bona fide good faith student. *5 if you have a follow-up question on this. Press *5. Okay, let's go on to our regularly scheduled questions. So, changing a spelling mistake of parent's name on birth certificate during pandemic. So, the parent's name on the birth certificates are incorrect. We, at the time of I-485, we submitted the printouts of scanned copy of the original birth certificates as well as notarized affidavits copies. Even though it may take several years for the dates to become current, we don't have the original birth certificates or the original affidavits. Due to travel restrictions, I can't even go to India to get the original certificates and the original affidavits. Any suggestions? What do we do if we are called for an interview now? Well, basically, first of all, remember that life still goes on. You could contact, I can think of lawyers, obviously, a lawyer in the city where you were born, and have them do some of the legwork for you. Or you can definitely present to the government the scanned copies as the best evidence available at the moment. I do not see what else you can do. I guess you could give copies of your Aadhaar card. You could give copies of your ration cards, anything that proves your date of birth. And if they want to check on the relationship between you and your parents, which is not relevant to an employment-based case, and I'm not sure if it's an employment-based case, you can always offer to do a DNA test. So there are two aspects to a birth certificate. It establishes who your parents are, and it establishes your date of birth. So Aadhaar card can be used as secondary evidence, in my opinion. And if necessary to prove a parental relationship, you could offer to undergo DNA testing, which is just quite a convenient way to get things done. *5 if you have a follow-up question. *5. Okay. So this one looks like it's coming from Atlanta. Where are you calling from? 770?
Atlanta.
Okay. What is your follow-up question? Go ahead, please.
Okay, so I do have all the documents like Aadhaar card, passport, like the relationship with the parents. The only thing is that I have the scanned copy of it. So the birth certificate, I don't have the original with me at this moment. So, like all are there, but in India. Also the affidavit by the lawyer, those are also in India.
Mm-hmm. I just told you that if you don't have the originals, you are going to say, I don't have the originals and I have no way of getting to them. But here are copies of my Aadhaar card. Here is a copy of my passport. And if you want us to undertake DNA testing, we can do that. We'll see how it goes. I can't really predict what the outcome is going to be, but I know this: if you took it to court, you probably would win. So I'm hoping it doesn't come to that. First of all, it's an impossible to anticipate date. We don't know when your dates are going to be current. For all we know, by the time it comes around to it, you'll be already done. But I think that's your best option. Provide whatever you can.
So the original birth certificate.
Mm-hmm.
So the original birth certificate is mandatory at the time of appearing interview, including the affidavit.
The U.S. government can, by regulation, insist on the production of original of any document that they want.
Mm-hmm. Okay. So will they give us few time so that we can travel and
Yes.
get that
Typically,
here?
for something like this, they should give you 87 days, which is the normal RFE time. So almost 3 months.
Mhm. Okay.
Okay. So
But
I'm
now
not.
the travel restrictions, so that's the only concern.
Yeah. See, my suggestion to you would be just hire a lawyer, pay them the money, let them do the legwork for you.
Okay. Like here in the US?
No, in India.
Like we already hired and actually got the affidavit done. So we have the affidavit copy, but all are there in India. So that is what you are referring to?
So there are two things. If you want some corrections done, get a lawyer. If you just want papers mailed, get anybody and pay them for whatever their time is worth. Pay them to have it FedEx to you. No problem. Okay.
But the original copy, if it gets lost, there's only.
Well, how many?
One more.
Yeah, I can't really comment about the dependability of mail, but FedExes are usually pretty dependable. In 30 years, they have lost papers for me 3 or 4 times, but that's considering thousands, hundreds of thousands of packages we have sent. That's a very small percentage.
Okay, so one more thing, like you just mentioned about the DNA test. So how they will cross-verify the DNA test with our parents who are like in India?
Well, that's the problem is during this time, I don't know. But during regular times, the way it works is, if I remember correctly, so there's a lab in USA that takes your DNA. They have a corresponding lab in India who either your parents go to them or they come to your parents. They collect their DNA. The samples from India get sent to the US lab. The US lab then compiles the report after doing the comparisons, and they send a report directly to the USCIS.
Okay.
So I'm going to have to go. I can't spend any more time with you. I have a bunch of other questions to cover, okay? Good luck.
Very quickly. Very quickly. Like if we are called for like an interview within 2 weeks, so like we can produce the
because
right?
There's such a ridiculously small chance, I'm not going to address that question. Okay? Good luck.
Okay. All right. Thank you.
Yeah, I have a little bit of time limit, guys. I got to move and I have a call scheduled at 1:30, so I'm going to have to be leaving a couple of minutes early. So India travel ban exemption for H-1B holders with US citizen child. Of course, they are exempt. If you have a minor US citizen child, the fact that they've got an H-1B, no problem at all. Definitely exempt very clearly. Okay. Another interesting thing is somebody asked me, what if the child is in USA and I'm in India? You can still travel. What if the child stays in India and I travel to USA? The law doesn't say anything about that. The proclamation simply says, if you have a minor US child, you can travel. You're not subject to the ban. So I think in all those situations, you should be able to travel, right? *5, if you have a follow-up question, *5. Okay. Travel alternative from Abu Dhabi as re-entry permit expires soon. Well, first of all, I remember that you had a question in here. What do I do if my re-entry permit is about to expire? Well, you cannot extend re-entry permit from outside the United States so far. I don't know of any such procedure. Okay, you have to be inside the USA when you apply. There is no email address to contact the USCIS. You have to go through their normal processes, but you can always contact your congressman's office. That's always a good way to do this. Just contact your congressman's office. Have them help you. What are the different outside US immigration centers? You're going to have to Google that. I think there are 7 or 8 of them, including Abu Dhabi. I think there's one in Ireland. So you can take a look at that. Just Google them. I don't know off the top of my head. Which outside US immigration center you recommend? Obviously, Abu Dhabi is the closest to you from India. So go for that. That's what I would recommend. My second vaccine can't be taken until 20th July. My reentry permit expires on June 21st. Yeah, there's no way to extend that. And the problem is, if you have been outside the USA for more than 1 year or more, your green card is, permanent residence is deemed to be abandoned. But when you have a COVID-like situation, I think the government is going to make some accommodations. But so far, they have not given us anything in writing on that. *5, if you have a follow-up question on this, *5. Okay. And this one looks like from India. Yes, India, go ahead, please.
Hello, Arjun. Rajiv, thank you so much for your service.
You're welcome.
Arjun from India.
Yes, sir.
So, based on the CDC guidelines, we asked to take 2 doses of vaccination and wait for 2 weeks before travel.
Right.
So, if I want to follow the CDC guidelines, then I would have to stay in India beyond the expiration date. This was not planned. The dates got changed only just a week ago. Before that, I was planning to take a second dose this week. The government of India changed the duration of second dose to 84 days, just 4 days ago. I have all the documentation with me, which means I can't travel before June 20, and I have to only travel to USA by end of July, which is for 40 days after my expiration. But I have all the documentation from Indian government saying that, and also letter also taken from Indian government saying that I can't take second vaccination before 84th day.
Good. That's good.
This documentation, I hope they will allow me.
Yeah, I think so. Look, listen, stop. Listen to me. There are 2 problems when you want to come back. One problem is, if your re-entry permit has expired and you've been outside USA for 1 year, the airline will not let you board the plane, because the airlines are a part of the compliance framework. However, a few weeks ago, Customs and Border Protection said to the airlines, there's a memorandum to the airlines. They said that let people board if they have an unexpired green card. Okay. What I read from that is this. Don't worry about them having been outside USA for 1 year or more. Let them come. We'll sort this out at the border, at the airport. That's the way I read it. That's my interpretation. So if I were you, I would be calling the airlines to confirm what I'm telling you is true. Okay. Will they let you board even with an expired re-entry permit after having been outside USA for more than a year? Number 1. Second problem occurs at the airport. When you come to the airport, the Customs and Border Protection is going to check out your case. And I think you have excellent documentation, right? You got proof. You wanted to come back. You got stuck.
Yeah.
You have no choice. I think they'll let you in. That's my guess for you. Okay?
Okay. Thank you.
You're welcome.
At the port of entry, right? Okay.
Yes, sir.
Thanks for this confirmation.
You're welcome.
I really appreciate it.
Good luck.
And I've been trying to call this USCIS number, and no one is
Yeah,
answering my call.
you have to keep trying. You have to keep trying. Our office does it all the time. I don't know what their inner secrets are. They always get through to someone. Okay?
Okay.
All right. Good luck.
Is there an email address for them?
That would be too easy. No, they don't do that. Okay?
Okay.
Good luck.
Okay.
All right. Bye-bye.
Thank you.
Next question. Yeah, they don't make things that easy for us. What was this? Okay, we did this. Now, the options, this is question number 6, where EB2 dates are getting current and no action on supplement J. Well, first of all, that doesn't really matter whether they have taken action on supplement J or not. They should be taking action immediately when the dates become current. So the fact that dates become current means the case gets assigned to somebody, and that somebody at the USCIS will immediately work on your supplement J also. So there's no time frame. What do you suggest I do? Because they're holding on to your case, and I don't think you can do anything about it. It is what it is. It isn't like you can prepare anything. You could file another supplement J if you have moved from the first employer. I think that is not a bad idea. Sometimes we even have our clients take supplement J to the interview by hand. Sometimes we file it and give it to them by hand as well. So I don't know, you'll talk with your lawyers, but there's not a whole lot you can do. There is no heroic effort you can do to comply. It is what it is. You wait. *5 if you have a question. *5 if you have a follow-up question on this. Okay, let's go on to, oh, there is a question. Guys, you gotta move a little quickly. Area code 209. 209, where are you calling from? 209. Hello?
Hello?
Yes, ma'am. Where are you calling from?
Yeah, hi. So right now I'm actually from I'm actually an FM student, but right now I'm stuck in
Okay,
India
stop.
because of
That's not the question I'm
I
answering.
wanna
Stop.
start
I asked only for a follow-up question on what I'm discussing. All new questions, if I have time, we'll do it at the end. Please stand by, okay? Yeah, no new questions, guys. We'll do the new questions if we have time at the end of this. Next question is H1B extension Nunc Pro Tunc. That's question number 8. My H1B was denied. They filed Nunc Pro Tunc in premium processing. If I leave USA now and I wait for Nunc Pro Tunc and go back home, what will happen to the petition? Nothing will happen. You'll have to go get a visa and come back in. You can leave while that is pending. Just make sure you've discussed with your lawyers if you have any unlawful presence issues. Yeah. Will the Nunc Pro Tunc get converted to general consular process? Yes. Yes, you'll have to go for a visa stamping. That's all. Not a big deal. Only problem is, Anur, I don't know if you are from Bangladesh, India, Pakistan, because if you're from India, you could have that problem that they're not taking any visas. So it all depends upon where you are from, but leaving would require you to get a visa stamp. *5 if you have a follow-up question on this. No new questions. Any follow-up question on this? *5. Okay. So, spouse of an H1B holder visiting USA on B2 visa. So the question is, if you get married and your wife has a B2 visa, can she come? And the answer is, if she's not covered by the ban, there's nothing in law that says she can't come to visit you. But try not to convert her to H4 visa. You have to move quickly, guys. 3 minutes after I moved on to the next question, you are clicking your *5. Stand by now. Let me finish this. So she's working in a company and she has branches in India. B2 was applied by the family and not by the company. She's already visited USA once with the B2. Can she marry a person in the US who's on H1 and come to USA and stay with the person? There's nothing that stops her from coming on a B2 visa. Okay. So you could definitely come on a B2 visa. Can the Customs and Border Protection at the airport give you trouble? Definitely they can. Will they? I can't predict. Okay. But it is not impermissible to use B2 even though you're entitled to H4. Just be truthful. Tell them at the airport, look, I cannot get an H4 visa because of the visa ban and the visa non-issuance. Number 2, tell them I am going to go back. I'm not going to violate the terms of my B2. It all depends upon how convinced they are of your bona fides, your honesty. Okay. So press *5 if you have a follow-up question. In the meantime, I am going back to area code 410 with the Nunc Pro Tunc question. Guys, you gotta be quick on the phone because I can't keep waiting for you to press *5. Okay. Baltimore, go ahead. Maryland, 410.
Hi, Rajiv. Thank you so much. I will just wrap it up very quickly. So after waiting for 2 months, we sent an email to USCIS and they said that we have not received any Nunc Pro Tunc request for this beneficiary applicant. I don't know what happened, whether the documents were missed or not, but my company is now filing again with another lawyer. So the only question was, I'm sorry. Can I ask a question?
Yeah. No, I'm terrible. That's just too bad, really. Keep going. Okay. So
Yeah. So the only question, two questions. The first question is, can my company still opt for the Nunc Pro Tunc because it's been now 3 months since my extension was rejected?
that's a
Can
long
they still
answer.
file the Nunc Pro
That's
Tunc?
that's a very long answer, Noor. Because I just don't have the time to give you the whole answer. Theoretically, yes, but they should take some action against the old lawyer who was supposed to have filed it on time and they did not. Let the lawyer either respond to that in a bar complaint or let them give you proof that they have already filed. So that's a long answer. Theoretically, the answer is yes, they can. Your new lawyer should be able to figure it out. Next question.
Okay. The next one is, let's say if they file the normal processing now and I go back, it's been like it will be my 3 months as an unlawful presence.
That's not a
If I go
problem.
back now and
That's not a problem. Look, unlawful presence is zero sum. Either you are unlawfully present 180 days, then all hell falls on you. But up to 179 days, it's not a problem. But make sure you don't have 180 days. Talk to your lawyers. Make sure they calculate. If you leave before 180 days, there is zero effect on you. I have no problem with that.
Okay, and the 180 days will start from the day my extension was denied, right?
Long answer. Dangerous for me to answer.
Okay.
But normally, if an extension is timely filed and it is denied, the unlawful presence begins from the date of denial. Correct.
Okay, all right. Thank you so much, sir.
You are very welcome. Good luck, sir. Okay, so we did the B2 visa, cross-chargeability. Okay, I don't know anything about DV, you guys. I don't do DV lotteries. You don't need a lawyer for that. But I can take a look at the rest of it. First thing is the green card queue based on place of birth or place of citizenship? Place of birth. I'll be in EB2 category. I'm pursuing master's degree. Fastest way depends upon where you were born. Are you on the telephone? Press *5 if you are. Are you on the telephone? Press *5. Okay, so I don't know which country you were born in. It depends. That determines the speed of your green card. They can apply for, your company can apply for your green card anytime, even before you join them. Should you do it on OPT? Actually, Yuri and I did a video on that and I haven't had a chance to upload it. I will upload it this week and coming long weekend. There's a lot of backlog I've got to clear up. I'll take care of that. Go to my blog and watch the section that will be updated about how soon can you file for a green card as a student. Okay. So the best case scenario, you join the company, they apply for my H1B. As soon as they can apply for green card. No, they can start your green card even before you join. I have no comments about DV, so I'm going to leave that alone. Getting US citizenship. Once I get the green card, do we need further 5 years? Yes. And the rules are more complicated than just 5 years, but you need minimum 5 years before you can file for naturalization, unless you are filing through a US citizen spouse. Then it's 3 years. You cannot count the period before H1B, before a green card for that stay or that residency or that naturalization. Okay? *5 if you have a follow-up question. I don't think you're on the phone anyway, so okay. Oh, there is a follow-up question. Area code 234. 234, where are you calling from?
I'm calling from Kentucky.
Okay, go ahead, sir. How can I help you?
I'm not the person, but I have a follow-up question
No
on that.
problem.
I'm on the same
problem.
boat, and I was thinking
No problem.
that if I was born in India and I recently got my H1B and my company wanted to file a green card, what is the realistic wait time on it right now? And are there any downsides of applying for a green card right now since I got my H1B very recently?
No. There are huge advantages to filing a green card as early as possible. Because in a couple of years, you will become completely independent of the consequences of leaving this employer. you'll be able to carry your green card over to the next employer. You have to start it all over again, but the priority date will be yours. So start a green card as quickly as possible, always. Okay? Sir.
And what would be the realistic timeline?
I don't want to comment on that. Anywhere from 10 to 20 years. But the thing is, green cards are supposed to move more quickly in the coming 1 year, starting October 1st. I don't know how quickly they will move. We are also expecting that the laws will be changed. How soon will they be? We don't know. But there are several changes possible. There's nobody who can predict for you even a fuzzily perhaps reasonable estimate. Nobody can give you an estimate. It'll take whatever time it'll take, but the good news is if you start early, you become relatively free a lot earlier. Okay?
Sure. Thank you. Just one last one. That is that right now I would be in EB3 categories, and since my job required just bachelor's, should I be aiming for a job which requires master's?
No. Right now, listen. The most important thing is getting your priority date. Start your green card, whichever category, as early as possible. And by the way, right now, EB3 is moving faster than EB2 anyway. Okay?
Okay. Thanks so much.
You're welcome. And the thing is, if, let's say a year down the line, you finished your master's degree or 5 years are over, or the job requires a master's degree or 5 years, bachelor's plus 5 years, you can do a green card again and carry the priority date over to the EB2. That's essentially a conversion of EB3 to EB2. Definitely file EB3 as quickly as you can. Okay?
Got it. Thanks so much.
You're welcome. Good luck. Okay. So, oh wait, did I miss something? No, we did that. Then we have question number 11. H-1B worker moving from USA to Canada on OPT, reporting in US visa regulations during the process of transfer. So my company is going to transfer me to Canada. My current visa status is OPT, which is F1. If the transfer process gets completed before completion of my work authorization period, can I move to Canada? Hey, listen, when you move to Canada, you need Canadian work authorization. You should not need US work authorization. Sitting in Canada, you could work for a US employer without having to worry about immigration process. How should I fulfill 12 and 18 months OPT reporting to DSO? Why do you need to report? Once you're outside the USA, you are no longer on OPT. You have to have permission to work in Canada, but sitting in Canada, you could work for a US employer, no problem. Is there any negative impact on US visa? No, not at all. This is absolutely fine. Star 5, if you have a follow-up question on this. Star 5. Okay. Press star 5. No? All right. So question number 12 is visitor visa for parents while green card is pending and delayed. Given they have a pending green card application, can we safely apply to renew their visitor's visa? You can. I don't see why not, but are they really doing visas right now? Will they be stopped at the port of entry? They could be. That's why I'm recommending all these folks with a pending green card to clear customs and immigration in Abu Dhabi. Because if they refuse you, you only have to fly back, I don't know, what, a couple of hours, 2-3 hours, instead of flying back 18-20 hours. But normally for parents of US citizens, they'll have to be real schmucks to create this problem. I don't think they should deny them entry really. Is there anything that can be done to request the US Embassy to call them for interviews? Nothing. There are literally hundreds or thousands of people in this situation. I don't see what you can do. Star 5, if you have a follow-up question. Star 5. We are moving along quite well. I have only 2 more questions left. After that, I'll open the floor to new questions. So now question number 13 is H-1B validity and remainder option. Let's see. I worked in USA on H-1B 2017 to 2018, 1 year. I came back due to H-1B extension denial. Changed employers in India. I want to come and study on F1. Is my H-1B still valid for 5 more years? Yes, it is. So at least till 2023, you should be exempt from the H-1B quota. Till 2023, maybe till 2024, 6 years after it was approved. You should not have to go through lottery again. Star 5 if you have a follow-up question. Star 5. Okay. Now, here is a question that's very difficult to answer on a community conference call. So you've got a couple of companies in the background who did your green card. You never worked for them. You're working for a third company. One of the companies whose I-140 you've used to file your 485 has been convicted of fraud, etc., etc. Visa fraud, mail fraud. I'm currently doing AOS. Is it mandatory to file new I-140 with consular processing? Well, I do not know. This is something your lawyer should be advising you. Can the 485 be moved to another I-140? Can you? In my view, yes, it can be. But what if the I-140 is deemed to be fraudulent? Then I think you won't be able to use that I-485 because it was based upon a fraudulent I-140. You know, the million-dollar question is, was there fraud in your I-140? I've had cases like this. Past cases where companies committed fraud, but they did not commit fraud in the green card cases. We were able to get all the clients through. So a lot depends upon the facts of your case. Can you try moving it to another I-140? Sure. You can try moving your 485 to another I-140. My only concern is, if the government comes back and says, no, you filed your 485 using a fraudulent I-140, therefore that 485 was never any good, then you have a problem. So the practical solution, Kumar, is this. Whenever your filing dates become current again, file another 485. Okay. Forget about the fraudulent I-140. Use the genuine I-140 and file another 485. Why not? Let them both stay pending. Is it illegal? No. Does the government not like it? They don't like it. What do I care? As long as you reference the pending I-140 by the right A number, you should have no problem. I've done this many times before. Press star 5 if you have a follow-up question. Press star 5. Yeah, you should really get together with your lawyers and figure out the detailed strategy. This is not really that unmanageable. Okay? Anybody with any question, press star 5. I can keep going for at least 20 minutes more. No more after that. 20 minutes. Okay, let's start with area code 978. 978, where are you calling from?
Hi, my name is Chris. I'm calling from Boston.
Yes, sir. Go ahead.
So my situation is that I worked for my previous employer from 2008 to 2012.
Mm-hmm.
And while I was working there, they filed for my I-140. It was approved. So fast forward 8 years, 9 years after, I changed some employers. And now I approached them in the month of October last year to file for my I-485, which they, gracefully did for me with the application of the I-485J supplement. Now I'm working with employer B right now. Now, can I port from a future job? I know, I've seen several of your videos regarding this in the YouTube, and you say the Yates memorandum clearly suggests that I can do so. But when I look at the Yates memorandum, I do not find that reference about porting from a future job to another job.
Try looking at the adjudicator's field manual. The Yates memorandum of, I believe it was May 2015. I believe that was the year. It was 5/15. So take a look at it. It's somewhere there in the memoranda. There's very clearly settled law. There is no doubt about this. You can port from a future job. The only problem is the future job 485 should have been filed in good faith. You should have wanting to join that employer. The employer should have the job open for you. As long as that is true, you can port based upon, even though it's a future job, you can port from it. No question, this is settled law. Anything else?
Okay, So, can I continue with my current employer? Means I can
Okay.
file this. I can approach this company
Yes.
and ask them to file about I-485J as well.
You
Though
should.
I did not work for
You
them
can.
in filing.
You can. But please discuss with your lawyers details. I can only give you general fuzzy guidelines. I don't know the whole case. Talk to your lawyers. Theoretically, a person can port off of a future job to any employer, including the current employer they are working with. Okay? I gotta move.
Okay.
Okay, guys, no, I don't have time for one more question. Right now I've got like 11 people waiting. I think I can do maybe 1 or 2 or maybe 3 at the most. They have scheduled me for a 1:30 appointment, so I have to leave like a couple of minutes before that. 630, where are you calling from? 630, where are you calling from?
630. Okay, hi. Rajiv ji, this is from Chicago.
Hi, ji, sir. Go ahead.
Okay, thanks so much for doing all this. But anyway, I'll keep it straight. So I had 2 questions, time permitting, but it looks like there's no one. So I'll stick to one, which is probably. So my question is, like, if let's say 2 persons applying for 485, okay, and this is a very generic question. So let's say 2 persons are applying for 485, and then the first person's priority date is later than the second person, okay?
Okay.
Since the first person applied for the 485, however, his priority date is later. So, and let's say both of them are priority date become current. So who will get the priority here?
Okay. So I understood your question. I understood your question. So first of all, USCIS does not do first in, first out. It doesn't quite work like that, because a lot depends upon how much time do they spend doing security checks or other documentation. But all other things being equal, once 2 485s are filed, one is filed before the other. The one that is filed before should be processed earlier because its processing date is earlier. Because see, there are 2 races here. First race is to file the 485. That can only be done when the priority date is available. Once it is filed, the second race is the processing time. How long does it take for them to process the file? So in a perfect world, the processing time should be orderly, and they are not. So you really can't predict. Okay?
Okay. So bottom line, whoever applies first, they'll get it.
They should, but not necessarily.
Yeah.
They should, but they're not necessarily.
We really don't know.
We don't know.
That's an ideal.
Exactly. Okay?
Okay.
Good luck.
Got it. Thank you.
You're welcome. Okay. Now, the next one is, I guess it's New York, right? 212? Area code 212, New York? Hello?
Hi.
Yes. Yes, sir.
Hello?
Yes, I can hear you.
Yeah, I have applications for the H4 visa. So, for my wife, like, if she is like H4 holder, can she work like from YouTube, Twitter, for some online accounts while
No. I've dealt with this question many times. In my view, any work that you do that generates income on H4 is illegal. Okay?
Okay.
Good luck, sir.
Sounds good. Cool. Thank you.
You're welcome. I think we are back to 234, which was what, Arkansas? Area code 234, Arkansas?
Yes, it's from Kentucky.
Oh, Kentucky, sorry. Okay. Go ahead.
So my question was, once your company files for your green card process, does it become difficult for the company to give you promotions? Does it become difficult for you to travel?
Very lengthy, very fact-bound question. My answer is still apply for a green card as early as possible. There are so many ways to take care of all these issues, small issues. Don't worry about those. Don't keep your eye on the main issue. Apply for a green card as early as possible. Okay? All of these ancillary issues can be taken care of. Not a big deal. Good luck. Virginia, area code 703. Go ahead. Virginia. Okay. Hello, Virginia. Area code 703. All right. Let's go to California. California, area code 408.
Sir, this is about a green card situation.
Right.
I flew out of US in October 19, and I was planning to come back in like 4 months or so, like in Jan, Feb, but that's when the COVID hit.
Right.
And I didn't file the reentry permit when I exited because I was planning to come back early. So now, since then, I'm kind of afraid to fly. So can I fly back now? And
I just dealt with this issue. You may have logged in late. Somebody else had a similar problem. Their re-entry permit was expiring. You have been outside USA for over a year and a half now, right?
Yes, sir.
Okay. Did you have a re-entry permit?
No, I was not planning to be out of the US for that long, but it's just the COVID causes.
Okay, this is a difficult question to answer in the time that I have, but listen to the recording of today's call. I should have it up by tomorrow. Listen to the recording of today's call.
Okay.
Call me back either in a couple of weeks when we do the next conference call, or talk to your own lawyers, see what they suggest, but you would have all the broad outlines of what I'm suggesting, what you should do. Okay, so wait for the recording to be up. You may not have any more questions after that. Okay.
Right. So SB1 is one other option which I read about.
Yeah, but SB1 is gonna take so long. Are they even doing them right now? So who knows? Okay.
Oh.
Good luck.
Okay, sir.
703, Virginia, go ahead, please.
Hello, Rajivji.
Hello,
I
sir.
have a quick question.
Yes.
I'm working with employer B, and I filed my I-485 in October, downgrade.
Okay.
And there is a chances, right now I completed my 180 days and I'm eligible for AC21. And right now...
Hang on, sir. Sir, 1 second. Is your I-140 approved? The downgrade is approved?
Yes.
Very good. Okay. And your 485 was filed more than 180 days ago, right?
Yes.
On the date the I-140 downgrade was filed, there was no intention to lay you off, correct?
No.
Okay. And you were still working for the same employer at that time, right?
Right.
Okay. So now...
I'm working to...
Go ahead. You're working?
Right now I'm working for same employer, but my layoff date is scheduled for July 30th.
You should not have any you should have no problem. Okay? Because first of all, even if you don't have a job for a few months, it's not the end of the world. Find a job. When you have a job and you know you want to stick to it for a while, file your supplement J. In the meantime, the only time you could have a problem if the government sends an RFE saying, it looks like you've left that job, give us supplement J, you've got 87 days. You got plenty of time to procure. Not even a job offer is all you need.
Yeah. And my employer A, who filed my EB2, and I have a priority date of 2013. Initially, he filed my I-140, and he's ready to take me. So my question is, if I go to my employer A, and if the dates, EB2 dates move forward, and the I-140 with employer A is not revoked yet, it's still active. And can I interfile to EB2?
Absolutely.
EB2 dates move forward.
Absolutely. Absolutely. No problem at all.
Okay.
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 Good luck.
Great.
Good luck. Good luck, sir. All right, you guys. It's been great talking to you as always. I love to hang out with you guys. I wish I had a little bit more time. But good luck, and I'll see you again in 2 weeks. Be well, everyone. Bye-bye.